All right, we seem to be back. I think we can resume. Mr. Malou, can we resume? There are still members of your team missing, but in the interest of time.
Yes, we can resume.
Very good, please.
May I point out one correction, if I may, Mr. President? Or would this?
If it's short, yes, the rebuttal. Okay?
Later in December.
This noise is a bit disturbing. Are you disturbed by the noise?
The noise I can deal with, but it's not a jackhammer, so I think I'm grateful for that.
I don't know how to interpret this. All right, let's continue.
Thank you, Mr. President. I just would like, as a matter of housekeeping matter, to remind everyone, both present here and remotely, that this is a confidential matter, and anything that is discussed here should be submitted to the parties before it's divulged. So just as a matter of
yes, that is noted and obviously addressed to everyone.
Thank you, Mr. President.
So
I'm at slide.
Mr. Molu, turn your microphone off, please. Thank you.
I'm at slide 49, and this is really, as a reminder, I don't think it deserves anything more than that. I've heard nothing that changes that. We're talking about Mr. Haas, who indirectly holds shares in Luxe through his family trust, which is a discretionary trust. And if you look at the excerpt, you see that the trustees have the discretion, the second box, to completely withhold distributions from any one beneficiary, and you also see that they have the power to exclude the beneficiary. So to the extent that this is a discretionary trust, the true claimant should have been the trustee, who's the owner, and not Mr. Haas, who therefore cannot have standing to be here before you. You see that they focus on the TPA and say that the TPA allows trust as being investors, but since you're an ICSID tribunal, the cumulative conditions must be met. So for purpose of the ICSID Convention, that's Article 25, which requires that there be a national of another contracting state, which means legal personality, and this is reference to the commentary by Professor Schroyer, and the trust not having a legal personality, again, cannot have standing before this tribunal, and the tribunal does not have jurisdiction over it. This completes my second part on the lack of jurisdiction over the claimants and their claim. I would like to say one word, which I forgot in my introductory remarks, and I think that it's the appropriate time to say it, and it's important. You heard Mr. Mulu say earlier that he was scared, that Mr. Seda somehow is scared about initiating anything because there will be some type of retaliation. We take serious issue with that. There has been nothing done by Colombia that was retaliation. So this is something that she has done, and that's her own decision in relation to the slander that she considers she has been the subject of. So it's not retaliation by Colombia, it's what Mr. Seda is doing and the reaction that he should expect as a result. So his action goes to that, and again, that's entirely legitimate. So Colombia, in its judicial, and you remember that that's part of the also the judicial, and that same letter refers to the UN Convention Against Illicit Traffic in Narcotics, Drugs, and Psychotropic Substances. That's part of that cooperation between the FBI and Colombian authorities.
forgive me, but we discussed all this in May, didn't we?
We did, but it's I'm answering Mr. Mulu when he says that he's scared and that there's a retaliation against Mr. Seda. I'm explaining that there's no retaliation. And finally, I want to refer you back to the cross-examination day 3 of Mr. Seda, pages 639 to 653, which is the entire discussion between me and Mr. Seda of these exact actions, and of course on the other side we didn't hear anything about that. So if anything, Mr. Seda is not scared. If anybody is scared, it would be the prosecutors who with courage in Colombia are actually going after these drug lords, and even my colleague sitting here, and I do recall that we have the equivalent of the head of the FBI in Colombia, the head of the CTI is sitting here with us. If the tribunal has any questions, you're here to answer. So I finish with the third part, which is the premature and abusive nature of these arbitrations. Point A, slide 55, is simply that the asset forfeiture are still ongoing before the Colombian courts. You have a timeline. I will not go through it. You remember that in May there was a discussion about whether or not Newport is afectado, is not afectado. You recall that the prosecutors treated Newport as afectado, so it had access to the file. Then, in 2017, there was the requerimiento, and that was appealed. As a result of the appeal, the process was suspended until in April 2022, the appeal court reinstated Newport as an afectado for the trial stage, which will now start, and this is all ongoing. So, and of course, Newport will have access to the full case and the trial stage. So, as a result of that, there's no final determination as to whether or not Newport is a bona fide third party without fault, and the merits of the Attorney General's asset forfeiture petition. Further, the court's decision is further subject to appeal as a matter of Colombian law. And finally, as you remember from the US submission in May, the responsibility of a state cannot be invoked until a final judicial act has been decided. And in this case, there is no final judicial act because this is all ongoing, and Newport has to make its claim to the Colombian courts, who will decide whether or not Newport is a bona fide third party without fault. Point B, the remedies and mechanisms allowed under Colombian law. It's a reminder, you heard this in May, Article 34 of the Colombian Constitution, which says that there's a right to a judicial decision for the forfeiture of assets acquired by means of illicit enrichment. Article 90 of the Colombian Constitution also provides that there shall be financial liability of states for unlawful damages attributable to it. So in the event that Mr. Seda has any issue with damages, the appropriate measure should be taken to the Colombian courts. And therefore, you see that Colombian law allows for full remedies under Colombian law for any damages caused for the wrongful or alleged wrongful conduct attributable to the state. And the reality, and that's my last point under C, not only these are premature claims, but they are also abusive, because what Mr. Seda and his acolytes are trying to do is to be compensated multiple times. At my slide 59. Mr. Seda and his acolytes are effectively trying to have 4 bites at the apple. So it's the have to cake and eat it 4 times. First, they want compensation from this tribunal, $255 million. It's, again, better than the casino. Then they want to eventually be able to seek compensation from the Colombian courts, which is still open to them during the process and throughout and at the end of the process. There is a legal action by Newport against La Palma, Argentina. We know that, but we don't have much information about it. So we don't know, but we know that it exists. And finally, and importantly, this is something you need to bear in mind. Mr. Seda is feeding domestic proceedings brought by the unit buyers against the state of Colombia by feeding them, and this is uncontested, by feeding them the process and records from this arbitration, and these are reports by Mr. Martinez, reports by Mr. Medellin, the confidential report prepared by investigator Paula Espinoza and addressed to Ms. Noguera, and finally the transcripts of Mr. Seda's improper recordings. This has been feeding the proceedings in Colombia, the unit buyers, and rather than be responsive to the potential actions that may be brought by unit buyers against Newport, Mr. Seda is trying to avoid responsibility by saying, hey, go against Colombia, don't come after me. And so he's feeding them this. So Colombia is, as a result, exposed more than one time. It's exposed to in the country by the actions of Mr. Seda, by the actions of unit buyers, and also in this tribunal for $255 million. This is abusive. It's nothing short of abusive, and this should not be allowed by this tribunal, who we say should be safeguarding the integrity of international arbitration as a mechanism and the integrity of this process and, frankly, the integrity of treaty protection under international law. With this and with my thanks to the tribunal for its patience and the interpreters, I pass on to Ms. Herrera.
Thank you very much, Mrs. Herrera.
Thank you very much, Mr. President, members of the tribunal. I will address now the allegations on the merits, both in fact and later on law. I will echo Mrs. Banifatemi's point made about the series of misrepresentations made that we heard from our friends on the other side early this morning regarding the law, the testimonies, and in fact, and the facts. So again, I'm not sure that we will be able to respond to all of them and correct all of them. And again, ask the tribunal to please refer back to the documents and don't take the word of the claimants as the real text or the real facts. Anyway, one point that it's quite important here, and I'm sorry, I know we walked you through this, the asset forfeiture law in May, but again, I think that's important to remember one thing, and it's what is the purpose? And the purpose is to forfeit an asset. The operative word is the asset. And that's important here, because as you have heard, the case of the claimants is Mr. Seda was target? No, Mr. Seda wasn't target. It was the Meritage lot. And in fact, the Meritage lot is not even owned by Mr. Seda. So that's the first point. Very quickly, I just want to remind the tribunal, again, that there are two phases in the asset forfeiture proceeding. The initial phase before the prosecutors and the trial stage before the court. Again, why is this important? I know that that seems pretty basic, because the claimants, through all the presentations, what they have done is apply the level of proof, the level of evidence, the level of determination that is to be applied and determined by the judge at the final stage, and bring it back to the beginning and say, no, 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 it's the prosecutors who should have done basically what the judge has to determine. And I will, again, refer to this. The two quick last points to recall: the asset forfeiture proceedings are not criminal in nature. And finally, to recall again, they are not subject to statute of limitations. And this is important, again, regarding the so-called due diligence performed by Newport. As you will see in page 64, we're trying to address the main allegations regarding the claimants have made regarding the asset forfeiture and why they say that they were wrong. In fact, they are not wrong. And the first one, and we heard again about this morning, is that the Attorney General Office had initiated the asset forfeiture proceedings and imposed precautionary measures based solely on a false kidnapping story. They refer again, we went through this in May, they refer again to the fact that it seems that there was no kidnapping story, at least there was not kidnapping as such when Sebastián López was coerced to transfer a property. He was coerced. Whether there was a kidnapping or not, that doesn't matter. That's the way that the Oficina de Envigado functions. They coerce payments of any debt. But this is just wrong. This is wrong. It's not based on the false kidnapping. And I'm going to go through this, and this is important again, because the claimants have said, you have to have perfect certainty of everything at the beginning. The prosecutor have had perfect certainty, all the evidence of everything covered at the initiation of the proceedings. This is not true. And again, here we have the claimants wrongly attempting to apply to the initiation of the proceedings and the imposition of precautionary measures, the standard of proof that applies at later stages of proceedings. Ms. Benifatemi referred how the asset forfeiture proceedings are a continuum, are ongoing, and in fact, it's almost a crescendo, as is normal, in any procedure that becomes a contentious proceeding, where more evidence is being brought into the forum. So first thing, what does the prosecutors, what do they have to do at the initiation of the proceedings? What's the standard? They can initiate proceedings if there are serious and reasonable basis to infer the probable existence of assets that could be subject to asset forfeiture. As you see, that's not a certainty, it's a serious and reasonable basis to infer. Now, as I have said, this continues, so it escalates, and then for the determination of claim, that is, when the prosecutor asks the courts, please do forfeit, or not forfeit, but please do forfeit, it requires an indication that there are grounds. So again, there are grounds of the forfeiture. And you see this very clearly in Mr. Caro's, Prosecutor Caro's requerimiento or determination of claim. And again, at the stage of the asset forfeiture before the courts, at the trial stage, that's a completely different standard. It's demonstration, yes. There has to be a certainty, a demonstration. So you cannot just, because it's convenient, I take the standard at the end that the judge will, in which the judge will make the determination, and I bring it back at the initiation of the proceeding. It just doesn't work that way. Now, we hear our friends of opposing counsel saying, Ms. Ardila, again, it was just on the study, it was just on the word of a convicted drug trafficker that she cites meritage, it was based on a lie. And in fact, in their PhD, they say the following. They misrepresent what Prosecutor Ardila said. And I read. That's from the PhD of the claimants. They say, at the hearing, Ms. Ardila testified that she relied almost entirely on the word of a convicted drug trafficker to seize the meritage property. And then you have what Ms. Ardila really said at the hearing, and that goes again, it's important to read the actual documents and the actual transcripts. And she's asked, and she says, when the case was admitted and opened before the asset forfeiture unit, it was based on a detailed report of the real estate recordation documents in connection with those pieces of property in particular. When it was submitted to me, it was accompanied by a very detailed study. Amongst the evidence was the tutela action submitted by Ivan Lopez together with other documents. Amongst those documents, so the ones accompanying the tutela, were other title studies. And let's look at what Ms. Ardila had at the moment that she initiated asset forfeiture proceedings and precautionary measures. So she knew, and we know that Ivan Lopez had been extradited on counts of drug trafficking, that he had connections with the oficina, that he had owned the meritage. That was shown in the title deeds of the property, despite what our friends on the other side had said, and I will go back to that, although we went extensively on that in May. 2, that there were several irregularities in the deeds, which included suspicion of forgery, and this was based on a study of the Superintendency of Notaries, which had gone and done 55 title deeds in the chain of transfer. There was also an interview of Mr. Arboleda, where it has demonstrated that he didn't have the financial capacity, etc. And there was evidence that the meritage lot had been the object of several transformations, physical and legal, in a relatively short period of time. As we know now, we're always saying Mr. Arboleda was the mango seller. Anyway, these are all clear hallmarks of money laundering. One point that I want to clarify here is we heard this morning that, in fact, Mrs. Arboleda, when she started, she had very little, and curiously, she started on the basis of a report that didn't mention the meritage. There are two different moments in terms of the collection of evidence that was carried out in this process. I mean, there are several, but in that initial phase. So when the procedure, when the case is open, this case is open by the Asset Forfeiture Unit, and sorry, I'm going to give the whole timeline because I think it's important. So we have Mr. Lopez Vanegas going in 2004, before, 2014, before the unit, the criminal unit, not the asset forfeiture unit in Medellin. The prosecutor is Ms. Correa, and she's specialized in the Oficina de Envigado. What happens? She looks at that, and she says, I'm going to send it to money laundering, and also to the different places where there are investigations of Oficina de Envigado. Then, after going to money laundering, there's another case. You know how they send copies? We refer several times about compulsar copias in May. They said the money laundering unit say, well, there must be here also, it seems that this is a case where asset forfeiture should be investigated. At that point, and before it's opened by Ms. Ardila, before it's assigned to her really, and she opens the case, the superintendency of notaries had this study that had conducted. So there was a lot already. It's given to Ms. Ardila. Ms. Ardila will start the precautionary measures, but it's important to say she requires then another study. And that's the other study. I mean, she receives this information, she looks at Lopez Vanegas, and she says, I'm going to ask for another study on the other properties of Mr. Vanegas. And that's the second study that the claimants had referred to, saying 47 properties. And I will go back to that when we talk about discrimination. But 47 properties, and the meritage was not there. Well, the meritage was not there because there had been already a previous study before the case started on the meritage. So surprise, it wasn't there. It was just supplemental and looking into Lopez Vanegas. So that was one first point that I wanted to make clear. Then a second contention of the claimants is that there was insufficient evidence of the illicit origin and the change of transfer of the meritage law. And that's not true. Again, the collection of evidence continue, and it keeps corroborating the illicit origin and the involvement of the Oficina de Envigado with the meritage law. The Attorney General Office failed to evaluate Newport good faith before imposing the precautionary measures. And here again, what are they doing, the claimants? So they conflate, or as the director was saying this morning, or maybe they don't understand, but I doubt it. What's the standard of proof that is required in the application? What's the standard of proof, but also what is the level of scrutiny that the prosecution has to have on the good faith or lack of good faith of the possible affected parties at the initiation of the proceedings, and what is the one that it's applied by the judges. And again, here we know, and this are Article 117 and 89 of the Asset Forfeiture Law, when you're dealing with anticipated provisional measures, which is the exception, but it applies when there's a necessity, when there's urgent, as it was the case here, where there were being sales and everything was going to be dissipated and their bona fide party buyers would be affected. There's not really a necessity. The law doesn't provide exactly. You have to conduct an analysis of the existence of bona fide third parties as required by law. You have to include them and notify them of the measure one imposed as affected. And Prosecutor Ardila did so. Now, when...
Excuse me, just to
yes.
help us, the claimant referred to an article, and don't find it immediately.
117?
Yes, which applies in the initial phase, which states in my recollection that also during this initial phase, it has to be ascertained whether the buyer has purchased the property in good faith.
In the initial phase, and that's Article 152, no, in the initial phase, that's not the initial phase, sorry. So we have, and that's Article 118, and that's in the requerimiento phase. And the standard is search and collect for evidence that allows to reasonably infer the absence of good faith. So that's the standard at the stage of the requerimiento. That's the formal forfeiture petition, not at the precautionary measure. So you're right, yes, there's a standard, they have to look, but the standard is really low. I mean, the standard is low, and it's infer the absence. Now, at the trial stage, both parties, and that's provided in Article 145, will present proof, and there has to be a determination, really, who's in the better position to prove, and that's provided in the law. It's usually in this case, the claimants or the ones that are having the affected parties that have the asset being forfeited. But of course, the prosecutor has the obligation to present proof, to try to rebut, etc. Now, I move to the I have
another question. I'm sorry, but
no.
Could you get back to slide 66?
Mm-hmm. It's 66. Sorry. Mm-hmm. Yes.
Did you say that at this moment in time, Mrs. Alila already had in hand the legal opinions as to the title research?
At the time of the precautionary measures? No.
No. Okay. Okay. That's clear. Thank you.
Had the internal studies of the register, but not the opinions of the experts. So, sorry. Sorry, one problem. So, okay. Now, moving, I continue on the point of the bona fide and the stages. And the claimants will say, look, you have to look at Article 87 of the Asset Forfeiture Law. And, that's a word they say, there's an affirmative obligation to safeguard the good faith third parties who might be affected by the actions. Yes. But look at the language of Article 87 this Article 87 refers to the normal precautionary measures, that is that when there's no that much urgency, which is not the case here, and so that there's a different level also. In any event, because for the exceptional, you will see Article 89 does not make reference to this. It's not really affirmative, to this obligation. It only says you impose them as long as this, the reason why you're imposing it is for any of the purposes provided in 87. That's the reference. Now, in any event, I'm not saying that you don't have to protect, but they are protected, the possible affected parties, they are protected because they are notified. Obviously, there's no point of notifying before you're going to put exceptional precautionary measures because that defeats the purpose, but they are notified as they were here. I mean, we heard through the, we have heard in May, and the claimants were quite surprised that actually they were included as afectados, and even with that designation, in the initial phase of these proceedings. And they were given the possibility to file documentation, including not the opinions, obviously, of Medellin and Martinez, but opinions and briefs, both Newport and La Palma. But anyway, further, the imposition of precautionary measures here was studied twice by the courts in the control of legality, and they were approved. And what is interesting, further interesting, is the claimants take issue and say, oh, well, you know, but how come, oh, they violated, they say it before the courts, they say they violated the level of scrutiny they have had because they have to go further. And you see at the end of slide 74, it says, what is the scope of the legality control of proceedings? Because what happened was that the claimants were making the argument, you have, before you apply the precautionary measures, you have to find that actually we are bona fide third-party buyers. And the court's answer, the appellate court says not. It says clearly, there's no argument showing the lack of minimal sufficient evidence on which to base the imposition of precautionary measures. Instead, what the appellant is seeking is a premature lifting of the restriction, recognition of a status that's the bona fide third party, which is only for the court's final determination, has no basis. Now, the claimants also rely on Article 152 of the Asset Forfeiture Law to argue that the Attorney General Office did not bother to identify, locate, gather, and file elements of proof regarding Newport good faith status. And this is wrong, because Article 152 does not refer to the initial phase. This refers to the trial stage of the asset forfeiture proceedings. And of course, we know for a fact that the prosecutors are gathering, have gathered, and are presenting proofs there. One of the other arguments that we have here from the claimants is, oh, wow. But in fact, Mr. Caro and Mr. Molu cross-examined Mr. Caro in the essence, like, actually, you're conflating the due diligence that was made by, between Corfe Colombiana and Newport, and you didn't analyze the good faith of Newport. This is interesting. This is interesting because you may recall that Newport always relies, and we will go back to that for purpose of how stringent its due diligence was in Corfe Colombiana. But leave that alone. The truth is that if you look at Mr. Caro's provisional in the requerimiento, you will say at pages 732 that in fact he did look at what was the due diligence that has been conducted by Newport. So did he not analyze? I don't think so. And further, and that's one of the things that is important to recall, who's the one that is the spokesperson for the property at the stage? It is Corfe Colombiana. And Corfe Colombiana, the good faith or not, and the due diligence of Corfe Colombiana was also examined quite thoroughly by the prosecutor Caro in its requerimiento. Finally, and it has been confirmed by the courts, and Mr. Prosecutor Caro also made it very clear, again, it is for the judge in the trial phase to determine whether Newport is a bona fide third party without fault or not. And I have these two quotes, that one from the decision in which the judge, the first instance judge, accepts the request for commencing asset forfeiture proceedings. And then we have an answer to Arbitrator Ponce of Mr. Caro explaining this point. So again, you cannot apply the standard of the end to the beginning in procedures that are supposed to be evolving and with their level of evidence it's mounting. Other of the arguments that the claimants made is the Attorney General Office should not have imposed precautionary measures since they are not reasonable, nor proportional, and they do not target illicit proceeds. Okay. again, this is a complete misconception, and it's an ex post facto created position of the experts. I will come back to this. But let's see. First of all, the precautionary measures were legitimately adopted by the Attorney General Office, considering the urgency of the situation. So what was Prosecutor Ardila saying? Involvement, and I said it already, Lopez Vanegas, the oficina and the chain of driver, the irregularities in the deeds, including possible forgery of documents, participation of frontman, physical and legal transformation. So if you tell me that there were no basis and they were being solved. And precautionary measures are always imposed. The question is if you impose it earlier on, the exceptional anticipated, or a bit later. But they are imposed because that's the only way to make sure that the assets are not dissipated when they before there's a determination by the court. Anyway. Again, just to recall, the legality of the measures was twice confirmed. And what is more, not only was the legality of the measures confirmed twice by the Colombian courts, but because the way that the asset forfeiture law is construed and the logic that enforcement, there's participation not only of the courts, but also of the Minister of Justice, of the Inspector General Office, the one that looks that the state, the administrative entities of the state are complying with the functions. And you have the legality of precautionary measures was confirmed by the prosecutor, by the specialized judge of first instance, by 3 superior judges of the Superior Court of Bogota, the Minister of Justice, and Inspector General. 7 public officials of different branches of the state. So unlike what Mr. Molu has represented this morning, it wasn't Ms. Ardila going and saying, oh, I put the paddock and I finished this and because I feel like, or because theoretically I have an interest, a further interest, and I will go back to, I will address that later on, in paralyzing this project. What she did was fully in accordance with the law. Now, we have now an ex post facto argument that, you know, what the Attorney General Office should have done was target the illicit proceedings instead of the meritage lot. Well, I mean, the asset is the meritage lot. You cannot target illicit proceedings or credits that are of personal nature. You have to go for the asset. But also, what the claimants had done is, again, misrepresent how this works. Under the asset forfeiture law, you have 16 different grounds for asset forfeiture. The first, 9 of them, with some variations, concern illicit assets given their origin or destination. And the remaining ones, which are the 10 and 11, are, of Article 16 of the asset forfeiture law, are the equivalent. And they may refer to the decision of the Constitutional Court. I will go back to that in a moment. But this is a different reason. This is a different ground. You don't go and simply because there's an illicit, I'm pursuing an illicit asset, and then I change to the other ground, and what I go is to the proceedings of the sale. It doesn't work that way. If what you're saying is the origin of this asset is illicit, I go to that asset. And this situation, what they are referring, are conflating the Article 1610 and 1611, it's another scenario. That's what happens if as a prosecutor or as the courts, I go and I cannot forfeit an asset. Well, that it's illicit in its origin. I go and forfeit an asset that is of licit nature, but it's in the hands of the same person that committed the illicit act. I will go back to that. So it doesn't work that way. You just cannot, and interestingly, there was something that Mr. Martinez had not referred to at all in the first opinion that he gave to Corte Colombiana. You may recall that Mr. Martinez appeared gave an opinion before to Corfi Colombiana, and then double hatting, he comes here, he's actually supposedly an independent expert, and he himself had to say, I have it somewhere during the hearing, saying, well, no, actually, yes, in a way, I cannot be completely impartial. Other of the arguments. Had the Attorney General Office evaluated Newport due diligence, they would have found that it was bona fide without fault. Again, we're going to the same kind of thinking. But this is important because let's look at what's the required standard of due diligence applicable under the asset forfeiture law. So what is the standard that the Constitutional Court has set to find whether there is if a person claiming to be a bona fide without fault party has to fulfill? And it says, the Constitutional Court basically states that in order to qualify as a bona fide without fault a party, that party needs to establish that it will have been impossible, that's for any prudent and diligent person to discover the falsehood of error of an apparent right of situation. So that's what the Constitution, that's the level, and that has not changed actually with the decision of 2020. And again, I will address that later. In fact, as you can see, this was prompted by a question. Mr. Martinez, arbitrator Perescano, asked him about this standard, and he had to agree. He had to say, yeah, I have to agree. You're right. That's the standard. Furthermore, what happens, and this is important, as Ms. Bani Fatemi was saying before, when you're investing in an area affected by violence and civil unrest. And recall, we know that for years Medellin had had a reputation of being a badass town. Violence reigns, civil society had been destroyed. No one seems to know how to put Medellin back together. And we see, and I'm going to page 85, what the Land Restitution Civil Division of the High Court of Antioquia district say in a decision of 2014. It says, when you're dealing, saying title studies do not suffice to infer good faith without fault to acquire premises, and that there should be extremely diligent inquiries regarding the social and political context and the effects caused by the internal armed conflicts. It cannot be clear. And why? Because this situation have impacts in both the grounds of the asset forfeiture, or, in fact, it can be, and that doesn't concern us here, but the victim's land restitution. It concerns us to the extent that we know that the drug dealing fueled the paramilitary, and the paramilitaries displaced a lot of the population. In fact, I think at one point, Colombia was the third country having the higher number of refugees, and it was all internal displacement. And let's see what happened. So Ms. Bani Fatemi reads from the brochure Mr. Seda, in which he is advertising his model of business. We heard it before, saying you pick up nice reasons, privilege dangerous, you get a bargain, and that's it. And Mr. Seda said, yeah, that's my strategy. So Mr. Seda knows where he's investing, that's the strategy, yet he doesn't want to have comply with the level of due diligence that he should. So, as we said, but we heard a lot of that during the cross-examination, and had been repeated, I would say, ad nauseum, that Newport has transacted in good faith. It had an extensive due diligence that had been done on the property. It included 4 title studies, a certification of the Fiscalia. Again, we have said that that's not certification, it's just simply an answer to right of petition. But let's look, during the cross-examination of Mr. Seda, 4 titles. So Mr. Seda said the 4 titles. The first one is the Otero Palacios of 7 March 2013, commissioned by Royal Property. Then we have one that's the title of Osorio Moreno, 17 May 2016, which was commissioned by Colpatria to give a loan for the project. Then he said, this is not a title study, we say, oh, and we hired Corfi Colombiana. And according to Mr. Seda, the mere hiring of a federally regulated financial institutions, which had impacted, federally regulated financial institutions, which had impacted, there's an error here, but it had guidelines and regulation. And we heard today, I don't remember opposing counsel saying, and the SARLAF, you know, the SARLAF had been approved of Corfi Colombiana had been approved by the government. That's not true. The government established some guidelines, and then it's up to the institution, the financial institutions, to follow, but they have the liberty of structuring it. So it's not, it had been approved.
Mrs. Herrera, forgive me, the court reporter asked for a short break. 5 minutes, okay? No.
I'm not speaking in Spanish. I'm doing my best not to run. It's awful. It's like a machine gun. Sorry, bad reference actually.
So this turns out to become a coffee pause of 10 minutes rather than 5. Okay. So let's say...
Tu crois qu'on arrive à boucler à 19h?
J'espère, oui. David, you see what you did?
Yes, according to my records, you have 1 hour, 19 minutes left. David, perhaps you wanted to explain what, if we were to go until the end of respondents' time, what would that entail with regards to the transcripts?
A longer turnaround for the final transcript tonight. It could be 11:30, 12, just depending on when we finish, because we have a lot of pages from today. And so we're burning the oil right now, trying to get it done as we progress along. So don't be surprised if it does come at a later time than I normally turn around. But I will send out a provisional rough draft, maybe about an hour, hour and a half after we finish here, so I can clean it up a little bit, make it more usable for you. And then the final will come much later.
It would be excellent. Thank you.
You're welcome.
Mrs. Herrera. Back to the due diligence, please. And you were on slide
87.
88?
Oh, yeah. Thank you. 88. Thank you, Mr. President. So let's talk about the studies, the so-called title studies. These are civil title studies, and these are patently insufficient under Colombian law to assess the risk of asset forfeiture, given what? Their limited material scope and then the temporal too, and I will go to that later. And this was clearly put by Dr. Reyes. Civil title studies are patently insufficient, and he says the main objectives of these studies is to verify that there are no problems of civil nature in the change of the tradition of property. To that purpose, the studies are temporarily limited to 10 years. And we heard again today of opposing counsel saying there were clean title studies. And interestingly, the way they were described were, again, there were not liens, there were not encumbrances. Yeah, that's what you do when you're selling a property, but that has nothing to do with the due diligence that is required and to show that you have you're a bona fide without fault party, and moreover, in an area where Mr. Seda and the claimants were investing. So this is limited. This is not the purpose for what the title studies are created. They help, they're part of everything. And in fact, we see, in the words of Ms. Ana Maria Palacio of Otero Palacio Law Firm, which is the law firm that performed the title study, civil title study for royal property, it says, it says, when she's asked, and this is taken from Pintura's primary arbitration that involved claims also regarding to the asset forfeiture procedure regarding meritage, obviously. And it says, well, when she's asked about the investigation, says, so I'm not sure that for my title studies, which does not include analysis of people who appear there as such, will affect my title study, because admission and opinion of legal civil matters of the possible defects that the property may have, or that it has any affectation, or it has liens, but not in matters of investigation, because that's not my scope. So we go to the material scope. And then again, you see when Corte Colombiana listed among the due diligence procedures that have been carried, says study of the company La Palma Argentina Company, carried out by Otero y Palacios, determining the legal viability from a commercial point of view. So it's clear this is patently insufficient. Then moving to 89, let's look again at the Osorio Moreno. And this is interesting. Again, I'm sorry, we went through this, but it seems that the claimants keep hammering on that, so I'm obliged to address it again. So we look at the Osorio Moreno title study, which is the second one that Mr. Seda said of the 4 title studies. Osorio Moreno was the one that was commissioned by Scotiabank, by Colpatria, part of Scotiabank, for a loan for the project. And you see, again, what they say, this is a real estate subject to a study free from all liens of limitation upon ownership rights. That's not asset forfeiture. And it says also, a disclaimer, it says, we are not liable for any information that may appear thereafter. That up to this day is not known by the lawyer office, such as information regarding asset forfeiture procedures, where such change has not been recorded within the registration pages review. Of course, if that is an enter that there has been a measure and it's in the registration of the asset forfeiture proceeding, it's a different thing. But as explained before, if there are asset forfeiture proceedings that are ongoing, there is the initiation, there are investigations, well, you're not going to find it. Definitely, you're not going to find it in a civil law, civil title study. And then again, there's another aspect, and as I recall earlier on, the asset forfeiture action is not subject to statute of limitation. And that's why also a title study of 10 years is clearly insufficient. And we saw this before. We saw that the title study of Otero Palacios was 10 years. And they say, and when they ask again in the same arbitration to Ms. Palacios, oh, why did you do a title study for 10 years? And she said, well, that was just a proposal. If the client say, no, I want you to do the entire change of recordation of titles, it can be done. So it covers the entire change. And during the cross-examination, Mr. Seda acknowledged the Newport failure to diligently commission the title studies. Ms. Benifatemi asked him, so what this shows is that the title study can carry shorter or longer terms, depending what the client asks. That's what it says. Yes, so to be clear, on the title study and every title study we have ever performed, we have never, ever directed, suggested, or made any reference to any law firm to perform a title study in one way or another. I mean, if I'm investing, and the quantities that supposedly I'm investing in this project, I will make sure that this is carried out in a proper manner. But moreover, you may recall that also the Osorio and Moreno title study extended to 20 years. And here during the cross-examination, so Mr. Seda says, so when we talked to Osorio Moreno, I think that's her name, I only talked to her once. She said, well, the thing is, because I asked the same question, meaning the duration. She says, the thing is that we're only required to do 10 years title search, but banks are particularly about reputational damage. And she says, you know, we go back 20 years because the banks ask us to go back 20 years because they don't want to have suffered any reputational damage. And President Sachs asked, when you learned this, basically, this didn't give you the idea to go back to your lawyers and to ask them, well, the bank said that it would be more prudent to go back 20 years. could you do that for me also? And Mr. Seda said plainly, well, no. Also, during the cross-examination, Mr. Seda had to admit that if they have done a more prudent title studying of 20 years, they would probably, as in fact Osorio and Moreno had, find the deed where Sierra Alta López Compañía en esa sociedad en comandita por acciones, represented by Ivan López, and in the case of sociedades comanditas por acciones, the socio gestor, I don't know how you say, the managing shareholder, is the legal representative, and he's obviously a shareholder, appear. And
may I
yes.
interject a question? At this point of time, if I understood correctly, Mr. Lopez was not on the OFAS list.
No.
So had she detected this indication, what is your position should have been made further? I mean, I presume the lawyer would have checked with the OFAS list. Lopez was not on the OFAS list, undisputedly. So what would be the shortcoming then?
Open sources, Google. And in fact, that's the case that Mr. Seda recognized and say, in fact, when in 2014, Mr. Lopez Vanegas appears and say, oh, well, actually, the Meritage lot is mine, I asked my lawyer, Mr. Lopera, to conduct a search, and he found, and he's Mr. And Lopera, my lawyer, found that indeed, Ivan Lopez Vanegas is a convicted drug trafficker. Thank you. Quick 2 points. We were told today that the due diligence conducted by Osorio Moreno went 60 years back. But in fact, there are a couple of things. It didn't went 60 years back. They took the 10 years, what was there, and then in the scope of this 10 years, they listed the persons, and particularly regarding the legal representatives, they only listed the legal representatives at the date of that search. So, of course, that's limited. And in fact, Osorio Moreno, sorry, did they find Ivan Lopez Vanegas? So you were told, oh yeah, but you know, many banks find Osorio Vanegas, Ivan Lopez, and nothing happened. Nothing happened. Nothing happened, but there are different. You don't know what kind of transactions different due diligence are made. It's different if I'm buying this for investing in this, that if I'm giving a loan in which I basically have a much more restrictive due diligence, etc. So you cannot meet those swapping affirmations. Sorry. Moving again to page 92. Then the claimants rely in what they call, and again, the certification of clean title, again, that doesn't exist under Colombian law. There's just rights of petition. And importantly, they say, with Mr. Reyes said is, actually, if you really know how asset forfeiture works, and we will expect that the lawyers, at least, of the claimant, and the claimant will know, given the magnitude of, or supposed magnitude of this investment, then you don't ask. I mean, you cannot rely solely on saying that the Fiscalia, oh, really? Can you tell me? Please tell me if anybody is here, and that's it. That's a certification. No, the Fiscalia gave you the information that it's public, that it's not confidential, that can provide at that point. But that's it. And also, what did they respond? They respond on the basis of the list that is presented to them. So if you present a list that is incomplete, also the response of the Fiscalia is going to be incomplete. The Fiscalia is not charged on doing the due diligence that the claimants should have done. And again, again, in the Osorio Moreno title study, in the disclaimer, you see this same kind of disclaimer. And just a quick note, you may recall that I refer and I ask Mr. Martinez during the cross-examination about whether really asking a certification from the Fiscalia is a proof of good faith. And I put to him an example of something that happens in the 90s where these so-called certifications were used to evade the law and to make a mockery of the law. And he said, well, I don't remember, but yeah, that happened. And at that time, the Attorney General was Mr. Cintura, the same person, and he was the one who had this problem. The same person that is making this petition. So it doesn't matter how you title it, you just say, bring me 3 third parties that are going to appear as the owners, and so that they can appear so they're having good faith. This is a ruse that had been used.
Is that part of the new evidence?
No. That's in the record. That's in the record. It's R121. Okay. Moving to 93. And we go here to the particular, to not use another term, view of the decision of the Constitutional Court of Colombia C-327. The first thing that I have to recall again, and I had referred to this, what was this decision constitutionality? The claimants at one point said this is a case. No, it's not the case. It's a decision on the constitutionality of a norm. What is the norm? Article 16 of the Asset Forfeiture Law. What is being analyzed? The 2 last paragraphs, meaning 10 and 11. And why whatever the court says doesn't apply to the rest? Because the court, the Constitutional Court, has already decided on the constitutionality of all the previous articles and is constitutional res judicata, and that's important. If they want to go back, they have to do so under Colombian law on a specific decision reversing a decision. This is not the case. And it's crystal clear that the decision refers to assets of legal origin. So, of course, the claimants take this and say, oh, and you see, no, the level of due diligence is only the assets. But they are talking, the court is talking here to the assets of legal origin. And I want to call your attention to one thing, and is when the Constitutional Court decides on these 2 articles, 10 and 11, decides they are conditionally constitutional. And what does the court says in terms of how do you have to read this conditionality? 1 minute, I have it here. If you give me a second. 1 minute. Yes. So, in the C-27 of 19 August 2020, it's Exhibit CMB 014 at paragraph 7.5, when the court says, how do you are to understand these 2 provisions for purposes of applying them and them being constitutional, it says, the court will condition the constitutionality of paragraphs 10 and 11 of Article 16, that again, is not the cases, the scenario that we're analyzing here, which is an asset of illicit origin. Paragraphs 10 and 11, Article 16 of Law 1708/2004, to specify, on the one hand, that in this hypothesis, the asset forfeiture shall operate only when the holder of the right is the same person who has carried out the underlying illegal activity. The holder of the right of some licit assets who has carried illegal activities, but the prosecutors cannot forfeiture assets, the illegal assets, and they have to go for the equivalent of the licit origin. And it says, carry out the illegal activities that support the persecutory powers of the state. And on the other hand, to point out that the aforementioned restriction is applicable without prejudice of the rights of third parties acting in good faith without fault, in whose favor in rem titles have been constituted over the legal property subject to asset forfeiture. And that's the case, for instance, what happened if there's a mortgage? The property is in the hands of the person that committed the illegal act, but whose licit assets are being forfeited in lieu of the illicit ones, and I have a mortgage. So a third party could have a mortgage. You have to make sure that there's protection, but that's a complete different scenario. So it doesn't matter the legal contortions that you saw Mr. Martinez doing and the claimants doing to apply this, that just simply doesn't follow. Whatever the court said does not apply on the level of due diligence, which we saw it's quite high, doesn't apply to the scenario of illegal assets. Illegal assets is stringent. You have to look at the assets. You have to look at the change of title. Now, moving to, I don't have the number of the page here. I don't have the number of the page. 94. This is a particular, I really find this interesting, the way that the claimants have tried to say they conducted a due diligence. Because it's completely circular. You have Newport and Corfi Colombiana trying to attempt to discharge the due diligence by allocating the responsibilities to each other and making really a mock of what are the anti-money laundering and the know your client obligations, etc. So you say, during the cross-examination, Mr. Seda was adamant that for him, having hired a federal regulated financial institution, EA, Corfi, which had guidelines and regulation, was kind of the summum of the due diligence, was evidence of the seriousness of the report due diligence. And he put it here, he says, during the hearing, he says, Mr. Seda, so I think we know, we were on the contract to purchase property, but the acquirer of the property is Corfi Colombiana, so they are doing the due diligence that is required by them. I'm relying on them doing the due diligence. So I have reliance on that they are going to do that work right. They are going to acquire the property. That property is going to be deposited in a trust, so they have to do it. They have to do it. And then it's quite interesting because we saw this in May, but Mr. Seda writes a letter to Corfi Colombiana at one point saying, can you please send me the communication of the approvals of the structuring of this business? And Corfi Colombiana answered and say, yeah, but remember, it is important to note that it was not the fiduciaria but the trustor Newport which directly negotiated the acquisition of the project plots with the company La Palma. And they basically said it was up to you to do the due diligence. And further, if we go to the following page, when we addressed this with Mr. Martinez, this was quite interesting because Mr. Martinez said during the hearing says, so Mr. Martinez at the hearing, basically what he said is Corfi Colombiana didn't have to do an enhanced due diligence regarding third parties with whom it did not hold a contractual relationship as clients or counterparts. So in the view of the claimants or expert, Corfi Colombiana was not responsible for the due diligence in the chain of transfer of meritage. So who was responsible then? He says, Mr. Martinez, my position after looking at the documents in this case is that the only obligated party I found in this case was the fiduciary Corfi Colombiana. But then at the end he says, in my opinion, Corfi Colombiana did not have to do an enhanced due diligence regarding third parties with whom it did not hold a contractual relationship as clients or counterparts. Who are the clients of the counterparts? Newport, La Palma? That's it. It stops. And further, well, I have already said that about the connection of Mr. Martinez and Mr. Cintura, the lawyer of Corfi Colombiana, and the impartiality of Mr. Martinez, to put it that way, the questions. Now, because during the discussions, and this is quite important, a lot of the time was spent during the evidentiary hearing in May regarding what's the relevant time to conduct the due diligence. And this generated a lot of questions. And so the first thing is, as acknowledged by the claimant's own expert, the relevant time to conduct due diligence, and that expert is Mr. Martinez, is when with transfer of property. And arbitrator Perez-Cano says, you said that good faith is evaluated based on the information available at the moment of the entry into the transaction. And my question to you is, what is the transaction? What is the relevant transaction? When does this arise? And he says, the moment that the act of contract with which the property is transferred is perfected. And then the claimants themselves say the sale promise agreement did not provide for transfer of title. There's undisputed. President Sachs asked this question, again, regarding the promesse de vente, and Mr. Malou confirmed, correct, that did not provide transfer of title. And then we got to why there is an ongoing obligation. And this all arises because even if you say, okay, it was extremely difficult, it was impossible, because we have seen it was an impossible, extremely difficult for the claimants to find Mr. Ivan Lopez. When I have a drug dealer coming and saying, that's mine, that raises a question. And there's no contention that that happened in early 2014. So we talk about the continuous obligation to refer to due diligence. And what Mr. Reyes clearly explained is, look, it's a very different proposition if you're talking of one-off transaction that is perfected just with the sale, that when you're looking at a whole complex project that involves several phases. And at the question of arbitrator Ponset, rightly so, of what does it mean that I have to be doing the exercise, the due diligence all the time, and given that the claimants have also asked, well, that doesn't mean that it's ad infinitum, Mr. Reyes said, no. It is if you receive information that changes the perception regarding good faith, then you're under the obligation to review your opinion regarding good faith. Now, we have heard today the claimants saying, oh, no, but the moment of the transfer, and they cite Mr. Medellin, was when the transfer of the property was made to the trust. And that trust is called the Meritage La Palmas Trust, referred as the parqueo. Curiously enough, parqueo means that it's parking, because it's going to move. That's the whole structure. And whose bona fide are we analyzing? We're analyzing Newport. And Newport is not there. Anyway, under this complex project, there's an ongoing obligation, if you hear something new that changes that, to do something. During the hearing, cross-examination, again, I said this before, it was clear that Mr. Seda his lawyer had done a Google search and had found that Mr. Ivan Lopez was had been extradited, and was a recognized drug trafficker. And you have the reference here. And this was before they started the construction of the project. So they say, oh my God, they stop all the project, that many people working, this is going, whatever we had managed to construct is going to ruin. Well, you assume the risk. In cross-examination, Mr. Serra recognized that Newport refused to redo the due diligence after learning of Mr. Lopez's claim. Ms. Banifatemi asked, you did not deem necessary, given the situation, and that you have a claim by someone who says, I'm the rightful owner, to restart maybe a due diligence, not a Google one, to have an attorney maybe look at the change of title, to go as far as possible? You did not think that right? And Mr. says we did not redo the diligence. So again, there was a conscious choice. I mean, I will submit that it's a reckless behavior, a reckless choice, but you assume the risk. And to the question of Mr. Ponset, actually, the Dr. Reyes gave an even more clear answer, saying, well, arbitrator Ponset, Dr. Ponset was asking, how many times do you have to renew the due diligence, with what periodicity, frequency? And Dr. Reyes said, every time a drug dealer tells you that a criminal office has dispossessed you of an illicit asset, and then in fact will be informed to the office of, should be informed to the office of the Attorney General. Conspicuous on all this, there's no mention of the claimants going to the Attorney General office. Now, having an issue with the pages. Okay. Now, because there was all this discussion, then the submission was like, oh, you know, and we hear it again, yeah, but you know, after we knew that Ivan Lopez was claiming property, we responded to his interview in the radio. We spoke to the unit buyers. Well, you spoke to the unit buyers. You tried to assure that everything it's fine. They will continue buying. Okay, and then now they submit the claimant wrongfully claim and they say that Corfi Colombiana thoroughly refreshed its due diligence. So that's the contention, the last contention in the post-hearing brief. Now, if you look at the just make a perfunctory analysis of the statement of the legal director of Corfi Colombiana, Ms. Betancourt Guzman, who we were referred today, and this was in another procedure, but has been incorporated here. What is it that Ms. Betancourt says that she did? She said, well, I mean, and we will see that actually she did not refresh. It says, I verified once again how the business deal with La Palma had taken place. We verified the title studies, the ones that have been conducted, and we know that were insufficient. We verified the searches that Mr. Cintura, we already talked about the searches and the petition, the limitations on the searches and the list and the petition, had performed. And once again, the tool we have is to search for the list of people whose name appear in the title transfer of property. We already showed that was incomplete. And those that appear particularly for La Palma that were generated, blah, blah. So clearly, rechecking patently insufficient titles, verifying the incomplete list, and in particular doing inquiring about La Palma, it's just looking at all the information. I don't see any refreshing as they want, and conspicuously absent from the alleged refreshed due diligence are searches regarding Lopez Vanegas. And they know, because Corfi Colombiana know, the Mr. Seda cell, I told Corfi Colombiana about the call. Okay. We move now to the claims of the claimant's allegations regarding violation of due process. So the claimants have submitted that they were denied the opportunity properly to participate in the proceedings that led to the seizure of the Meritage project. That's not true. We have shown, and again, to the surprise, apparently, of the claimants, that both Prosecutor Ardila and Prosecutor Caro, and you have here the evidence, and even in the requerimiento, Mr. Caro says, identificación, lugar de identificación de los afectados, and is listed the lawyer of Newport. And you see how, before that, Prosecutor Ardila had also included as afectado Newport. So I don't know where this idea that they were not included comes from, frankly. In cross-examination, and you know, Mr. Seda admitted, Ms. Benifatemi asked, so my question is very simple, not getting into legalese. Are you aware that in April 2017, the prosecutor recommended that Newport be admitted as an affected party? Mr. Seda, no one ever told me that. The Fiscalia recommended us to be affected parties. Never. Well, I submit that the starting an investment arbitration and claiming that they have been deprived of, there have been a violation of due process when the facts demonstrate the opposite is, to say the least, questionable. Anyway, now, at the trial stage, we have the decision of the second judge of the section of asset forfeiture, now that the court, and we know that the second judge of the Circuit of Medellin said, no, I don't consider Newport as an affectado. Why? Because in my reading of the law, only will be an affectado has in rem rights. He doesn't, you know, and this is not contested. We have seen already that Mr. Moulou answering to President Sachs said that there have been no transfer of title. And you will see also that during the cross-examination, when I asked Mr. Martinez, I said, so that is the judge's explanation that there need to be real property rights, that they would be, that for it to be, that basically you need real property, and here it's upper cap, and that's not correct. I mean, we're not referring to the real property, the company. There need to be real property rights, and they will be the affected parties. That is feasible. At least it coincides with your own view in the first opinion. And in the first opinion, and then in the cross-examination, he said, the general rule is that the affected parties are the holders of real property rights, rights in rem. That's a general rule. So at least this was reasonable. And in any event, this was revoked by the Court of Appeals, and we know that's part of the guarantees that the claimants have, and we know now that the claimants are fully participating, or we expect so, in the trial phase. We have again here the chart. And another point that I want to make very quickly is, in fact, because the procedures were, with the appeal of the decision of not being considered as affected parties in the trial phase, there has been no movement in terms of the procedure was actually suspended. So it's not that there have been a violation of the due process of the claimants who now can present all evidence.
May I ask, what is the time perspective of the proceedings that will now start to deal with the good faith issue, if I understand it correctly?
I have been told that 1 year. Whether that's really feasible, I don't know. I want to refer now and address that point in the following slide of why it takes so long, and also another point, which is, of course, they take the issue with the claimants take the issue with, according to Caro's testimony, it's 1 year. But the claimants take issue with the duration of the proceedings. But they are, considering the aggregated circumstances, there are reasons that explain why this had happened and what's reasonable. First of all, as acknowledged by Mr. Seda during the cross-examination, the file is thousands and thousands and thousands of documents. Yes, indeed. Just the part that had been submitted is 8,500 pages. The appeal was filed by Newport against the decision of the second judge, which of course delayed things. As explained by Prosecutor Caro, prosecutors and the judges specialized in asset forfeiture are each in charge of around 120 cases, and there is only one court of appeals specialized in asset forfeiture. The activity of the Colombian judicial branch was suspended during COVID pandemic. And this is interesting, because in an exchange between Mr. Seda and Mr. Mosquera on 11 September 2016, Mr. Seda says, saying, and if we don't pay and we have the land taken, well, we lose a lot, less considering that in any case it will be impossible to continue with the other phases. That's part of the context. This means that the necessary proof to take away this land is almost impossible. The process could take years. Of course, it could be. So this is interesting because this is September 2016, so shortly after the requerimiento. And Mr. Seda is well aware of the long duration of the asset forfeiture proceeding. There's no mistake. Now they're saying in this arbitration, oh, it was awful. He knew the duration. One quick point of that, and it was on Ms. Ardila again. The claimants had Ms. Ardila for 4 hours, I think, and that's the issue of they saying, oh, she lied. I'm going to address first the point of whether she knew or not. That we don't know. I cannot testify for her. Again, I just want to point out that the claimants had the documents. They could have confronted it with her complaint against Mr. Seda. They choose not to do so, and they put it to Mr. Caro. In any event, and the second point, and this is on the credibility of Ms. Ardila, it is not true that she lied when she said that she had no personal relationship or professional relationship with Mr. Mosquera. And if you look at the Spanish, it's very clear. When you say person, and the claimants are unhappy with any of the answers that were given of what was the process of thinking of Ms. Ardila. So they say it was the meritage that was target, and it was Ms. Ardila who only herself decided to do it. First thing, that assertion that did Ms. Ardila in the record saying, I took the decision myself, was in the context that she was pressed to say, oh, but Ms. Malagon didn't, and nobody told you to do something that goes to corruption. She said, no, I assumed that was my own decision. Nobody forced me to. That was, I studied the thing and decided to request the asset forfeiture. In any event, why the sister property is not in identical circumstances? because the effects are not the same. I mean, first, if you look, from 2006 onwards, the Meritage lot, the so-called sister property, had a different change of transfer, and a lot of transfers and connections with the Oficina that were only present in the Meritage lot, including the one of Guru, the model, but anyway, there's much more elements in that property pointing out to money laundering. Also, and this is what Ms. Ardila explained, is the Attorney General Office considered that it lacks sufficient evidence as to the illicit origin of the sister property. And remember, this goes back to, in August 1994, Jaime Orozco and Ivan Lopez buy a property from Agrícola La Granja. It's divided in 2 lots, but each one has its owns, how to say, pro indiviso, the, without, jointly, a certain percentage. Orozco, 25%, and that's a surface, 25% on one lot, 25% in the other lot, and the other one, 75%, 75%. And that surface of the 25% is 188,558 square meters. They are consolidated afterwards, but then in 2016, again, they are divided, and what Orozco Vanegas keeps is exactly the 25% that you had before. So I can understand, and this information about the percentages was from the beginning appear, and Ms. Ardila had it since the beginning. And I mean, you can look at her provisional determination where that will appear there, how she knew that it was 25, 75, etc. So I can understand she look and say 25%. I don't know if there's any illicit activity of Jaime Orozco. And I see at the end, he goes with 25%. Can I proceed to impose measures? And here there's not being a sale, there's no units being sold. Well, probably no. I have to look further. And what does she do? Precisely that. Okay, she imposed precautionary measures on the Meritage. In the other, she doesn't have the urgency and say, but I'm opening another investigation on the sister property and other properties. Now, we have been told that it was because Ms. Ardila is corrupt, that it was in collusion with Ivan Lopez, that she targeted the Meritage. But she targeted the Meritage, she opens, how does this go? She opens an investigation into the so-called sister property, and it's not her who then decides in that second investigation that actually let's prioritize other assets. We have shown, and I refer you to what was it's 114, our timeline, showing why the so-called coincidences are not coincidence. And in particular, as we said in the post-hearing brief, in fact, the reason that you see that the claimants rely on the alleged suspicion, coincidence in time, and the speed of the asset for future proceedings to support the corruption theory. But what they omit to say is that during this period, Lopez Vanegas filed a number of petitions before the Attorney General to reactivate the proceedings. And in fact, the asset forfeiture proceedings had started by the time that Lopez Vanegas said, please commence asset forfeiture. Why would I ask for something, if I know, for something that it's already happening? So it just doesn't hold water. You have heard in 114 a lot of arguments saying that Mr. Morguera was bragging about his influence, etc. Well, we don't know about that. Whatever he said, the truth is, and I refer to Mr. Seda in the recordings that he made of the meeting with the Attorney General Office, saying, I don't have anything, where I can say, really, Ardila asking me or anything specific. It's all hearsay. The people of the Fiscalia that supposedly appear and say, please give us money, no idea. We don't know. On the supposed corruption of Mr. Hernandez, who came here, despite all the cases that had, whose father was killed, being another functionary of the Fiscalia in his work. And they didn't ask him. And we had to produce thousands of files just to rebut press, which is innuendo. Anyway, nothing of that. They were, neither Ms. Ardila, Ms. Hernandez were confronted. You know and I don't have time, you know very well all the parameters and the requirements under each of the standards of protection in the TPA. Very quickly, you have an expropriatory, you have a permanent impact. There's no permanent impact here. This is a measure that it's ongoing. There have been no determination, and further, we will see if there's an impact or not. And I said again, there's redress if that's the case. Interference with reasonable back expectations. The claimants accepted the framework of the Colombian asset forfeiture law, and would you say that what I hear this morning is that the claimants find the asset forfeiture law, the Colombian, odious. They can find it that way. They even say, oh, okay, that doesn't follow international law. Well, the asset forfeiture law in Colombia has been followed by other countries. And in any event, that's irrelevant. The point is that was part of the framework when Mr. Seda and the claimants decided to invest. The character of the government action is not final. There's still not final decision. It's based on the existing framework. Legitimate expectations, again, we don't believe that we say legitimate public welfare. We heard that there was no legitimate public welfare. I have to tell you, fighting against criminal or organized crime, and I'm sure that everybody that is here from Colombia will agree with me, it's quite a legitimate one. I don't think that there's a single Colombian family that had not lost a person due precisely to the oficina and the violence created by drug dealing. So that's combating organized crime, compliance with due process of law. I show you how it has been compliant exactly in accordance with the law. No discrimination here. And this is a bona fide application of the asset forfeiture law. We move quickly to national treatment. We see that one of the elements is that the measure has to be applied to a foreign investor. Again, this is a measure applied to the asset. It's not applied to Mr. Seda. And again, the asset is owned by Colombian nationals. There has been less favorable treatment. That's not the case. And that's evaluated in like circumstances. I already touched on this. And there's no reasonable justification, even if there was a different treatment with the military law, could not. There was that treatment, and the imposition of the precautionary measures was urgent for the reasons I already explained. On fair and equitable treatment, where the standards is not arbitrary and unreasonable, I have touched upon this already. There is the origin of the asset. It was accordance, again, in accordance with fundamental procedural protection. I talk about the protections, the possibility to intervene, the legality control, again, was not discriminatory. And also to recall, the standard under the TPA doesn't include legitimate expectations. But even if there were, again, the claimants could not have legitimate expectations that the asset forfeiture law will not apply when they have not complied with what they have to do in the due diligence, or at least appears so far. And finally, there's, with the other projects, and there's no evidence of sufficient causal nexus between the measures applying the military law and the damages that they claim on the other projects. As to fall protection and security, remember here, and the same in regards to minimum standard treatment, the protection is predicated of the investment and not of the investor. And we have seen the measures, although very quickly, that were taken to protect not only the claim investment, I mean, investment, whatever it is. It's not, the investment has not been, the measure has been not against the investment, but also Mr. Seda as investor himself. Thank you. Thank you. So my colleague, Ms. Ripko Borman, will address damages now.
Damages. How much time is left?
23 minutes.
Okay.
Thank you. Thank you very much. I know, good afternoon, and I know everyone wants to go home. And indeed, Mr. Malou mentioned this morning that we should not get to damages and we should go home. And we should, indeed, because as shown in this roadmap that you have there, we have shown already that the measures were adopted in the protection of essential security of Colombia. We have shown that this tribunal does not have jurisdiction. We have shown that the claims are premature and abusive. And we have shown that, that Colombia has not breached its international obligations under the TPA. But still, I need to address damages in case you reach to it, and because there has been a lot of misrepresentations and things to correct this afternoon already from our friends on the other side. We had originally prepared more slides, but we had to reduce them to fit them into the a bit more hours. I'll need to rush through anyway the few slides that were left. So I respectfully request the tribunal to refer back to the PHB, where all the damages case is very clearly explained. Please move on. So it is undisputed that only the damages incurred by reason of or arising out of the state's unlawful conduct are compensable. And this has been confirmed this morning by Mr. Malou. Now, only 1/3 of the damages claimed by the claimants concern the Meritage project. This is undisputed, as it's also undisputed that the asset forfeiture proceedings also targeted the Meritage lot, not even the Meritage project, because as we said, it's an action that targets only assets and not the investors as such. So only 31%, if any, of the claims should be claimed before this tribunal. We see in the following slide that there's also no legal connection between the Meritage project and any of the claimants' other projects. Indeed, if you see all the claimants, and we've seen already at the opening, but if you see again, all the claimants that are in yellow have absolutely no connection to the Meritage. But even the ones, and also the projects that you see, Luxe, the 458, Santa Fe, and Tierra Bomba, are developed by SPVs that are totally unconnected to Newport. So there's no legal connection at all between this and the Meritage project, assuming that the Meritage was the target of the measures, which again was not. So now, if we look, for example, at the Luxe project, for which the claimants claim 44 million, which is 22% of the full damages claims. This morning, the claimants made the allegation that the banks accelerated debt and that, therefore, the Luxe, at least the construction of the hotel, had to stop because financing dried up. We searched really carefully the record, and there's absolutely no evidence, first, that Colpatria agreed to provide this financing. Second, that Colpatria ever decided to withdraw this financing due to the asset forfeiture proceedings. And in fact, if you compare Exhibit C-168, which is the letter that refers to the decision of Banco de Bogotá, which was the bank that was financing construction of the Meritage, in that letter, for example, the Banco de Bogotá really informed that it was accelerating payment, the credit, due to the asset forfeiture proceedings, or to the preliminary measures that had been adopted by then, and it referred to provision of the promissory note, which allowed acceleration of those payments. Then no such provision, if you look at C-135, which is the loan approval letter for Colpatria, no such provision is included. So there's nothing that will allow, for example, Colpatria to accelerate the payment in case of an asset forfeiture proceedings against Luxe, let alone against a totally unrelated project, which is Newport. Now, as I said, the loan was granted to Luxe by the Charlie, so it was not granted to Newport. Newport does not appear anywhere in that loan approval. And that, as I said, there's no grants. Now, assuming that Colpatria did decide to withdraw financing, there's absolutely no documentary evidence that the claimants ever claimed that Colpatria to give that financing back, because they did not have any grounds to accelerate payments. That's what a diligent businessman would have done. Now, they also, and a lot was said this morning, that the hotel was 70% completed. There's, however, no evidence that construction was halted because Colpatria allegedly decided to withdraw financing. Actually, they said that it was only 4 months away from being completed, so it's quite incredible that they did not have by then financing, especially when they say they are investors, and there's absolutely no evidence that they ever even attempted to provide own funds to complete this almost completed hotel that they claim as well would have been very profitable. So all this looks very unreasonable, and there's absolutely no evidence to show any of these steps that I'm going through. They also say, for example, that they tried to sell the project to alternative investors, but that they couldn't because of the measures. However, if you look at Exhibit C381, it shows that actually by November 2016, that's 3 months after the preliminary measures were imposed, Royal Paladin were still interested in negotiating the potential investment in Luxe. And we don't know if that ever went forward or not, because we don't know who is at the moment operating the Luxe Cabañas, which are operating, as the claimants stated this morning. Now, if we look what the evidence shows, and we saw this in the opening statement, it shows that by the time the precautionary measures were adopted, the Luxe project was already significantly delayed. It had experienced severe cost overruns, and financing had dried up. Now, even assuming that there is a causal link, the losses suffered in connection with the Luxe project are still highly exaggerated, as we will see later, and the maximum compensation should be 3.7 million and not 44 million as claimed by the claimants. A similar situation is with the other project. I will move a bit faster in the interest of time. So with Tierra Bomba, we saw already this, the evidence in the record. What does it show? That there's absolutely no causation, because the claimants did not own the land where they intended supposedly to develop the Tierra Bomba project. They did not have any approval by the indigenous population that was required to develop those projects. And indeed, what they had were promises to purchase 3 lots, but these were made with prospective sellers that did not have legal title over that land. Those contracts were terminated some years later, and what the termination contract says that they were terminated by mutual consent of prominent seller and buyers. What there's no evidence of is that the projects were viable, or that, for example, the claimants tried to find other lots in Tierra Bomba, which would have been the reasonable thing to do again if the project was so profitable as they claim they were. Now, there's the developing project, which is interesting because, in fact, this is little more than ideas and brochures. Still, they claim $54.5 million in connection with this. This is the 450 Heights Santa Fe Antioquia project. And there's, again, no evidence that these were viable, that they had financing, or that the projects were halted due to the asset forfeiture proceedings. What the evidence shows is that investors that were seeking to divest from Mr. Seda's other projects actually accepted interest in the Santa Fe Antioquia project. Even more interesting is the claim for 15 million in connection with what we call the future hypothetical projects, that 7% of the claim in connection with projects that were not even ideas. So we said the developing projects were little more than ideas. These were not even ideas. Still, the claimants are claiming 15 million in connection to this. There's no evidence against that they were viable, that there was financing, that they were impossible to develop due to the asset forfeiture proceedings. What the evidence instead shows is that Mr. Seda was still operating the Charlie Hotel and that he kept receiving offers to operate other projects. Moving to the next issue, and it's assuming that you find that there's causation and you actually need to assess the damages. There's a dispute between the parties as to which method to apply. It is undisputed that the criteria of Rosoro applies to determine whether a DCF method is appropriate in case of not going concerns. We saw a very similar slide during the opening, and all we did at the hearing was to confirm. So, for example, one of the criteria is that there should be an established historical record of financial performance. The claimant's only operating hotel, which is the Charlie Hotel, is very different in nature from the claimants from the other hotels that they would have developed. None of them were developed. So just to recall, the Charlie Hotel had 42 rooms. It was in central Medellin. And as Mr. Seda confirmed during his cross-examination, it was known for its relation to prepagos, which is prostitutes in Spanish. All other projects were more family-oriented. Also, they refer constantly to the Meritage that was sold. Actually, phase 1 of the Meritage project is the only phase of the project that had reached the equilibrium point, and as demonstrated by Dr. Hearn, it was sold at a loss. So really, the track record of the claimants speaks for itself. The second issue, for example, reliable projections of future cash flow. It's undisputed that the business planning on which BRG relied have not been verified by third parties. And as confirmed by Mr. Seda, they are highly unreliable because he said when faced with one that it was not possible to determine whether it was the last version of the document or just some undated draft of a brochure of one of the projects. Now, just in the interest of time, Dr. Hearn does, and we, our position is that a cost approach should be followed. But even if the tribunal decides to go for a DCF, Dr. Hearn explained that because the claimants had invested in a competitive market, the result of going for the cost approach or for a reasonable DCF approach or a DCF approach based on reasonable assumptions is very much consistent. Now, the claimants seem to question that the hospitality and real estate market is a competitive market. It has been shown that there is no barriers in principle to entry, so it is a competitive market. If there's any barrier that applies in the particular region where the claimants have invested, is that most of the land in Antioquia, where Medellin is largely in the hands of narcos. And their kind of blessing, to put it in a way, is needed in order to do business there. So if there's any barrier to entry the market, that is the one. Otherwise, it's a fully and not perfectly, because there's no perfect market, perfectly competitive market, as explained by Dr. Hearn, but it is competitive. An important point on this is that the claimants have, other than contesting the cost approach, they did not contest the cost valuation made by Dr. Hearn. So if the tribunal decides to adopt a cost approach, then Dr. Hearn's cost valuation is uncontested. But let's see, because for the sake of exercise and completeness, Dr. Hearn also performed a DCF valuation on the basis of reasonable or supported assumptions. And let's see, for the hotel, which are 80% of the damages claims, despite the fact, as I mentioned, that there's no operating hotel other than the Charlie, the claimants are claiming $77 million. Only 25.5 concern the meritage, and that's on the basis of what we call the exaggerated assumptions. Now, if we go to the adjusted assumptions, let's see, for example, the EBITDA margins. The claimant, or BRG, has applied a 38 to 56 percent margin without any support. Now, if we see, for example, if Dr. Hearn adopted a 19 to 22 percent margin, which is in line with the Charlie Hotel that the claimants operate and that they claim is a very successful hotel. And the impact on the valuation is huge. It's between 51 and 61%, which equals 66 to 79%. Now, adjusting each one of these key drivers has such a significant impact. So if you just follow Dr. Hearn's approach on EBITDA margins, then the valuation is reduced by between 66 and 79%. If we go to the discount rate, BRG applied a 7.9 discount rate, which, as explained by Dr. Hearn, is highly unrealistic because the claimants themselves have offered investment at an internal rate of return of between 25 and 28%. Again, if only adjusting this driver has an impact on the valuation of between 72 and 105%. Failure rate, again, this was highly broadly discussed because BRG decided to apply a 0% failure risk for Meritage and Luxe and only at 23% for projects that are little more than ideas, as we mentioned, and for which they didn't have the land or permits. This is fully developed in the PHBs, and in the interest of time, I respectfully refer you to the PHBs. Similar impact applies to the real estate operations, and I will only, the real estate claims amount to 20%, 21 million. If I may correct only or comment on the speed of sales, BRG applied a speed of sale of up to 14.4 units per month for the 450 heights. This is up to more than 3 times as fast as selling that they assume that the 450 height project would have sold up to 3 times faster than the Meritage Phase 1 sold. The Meritage Phase 1 sold at 4 units per month during the first month in which it was in the market. Again, it was sold at loss, so it's not such a great comparator. But even taking it as a comparator, the one that BRG, on which BRG relied, 14.4, is highly unreliable. And if we adjust only this, then the difference is around 3%, which is 15, around 3 million, sorry, which is 15%. Similarly, unsubstantiated and exaggerated is the claimant's claim for lost fees, which amounts for 85.9 million. Only 28.2 million concern the Meritage project. There is no evidence that the claimants would have operated the yet-to-be-built hotels. As I mentioned before, there's also not evidence, for example, that they operate the Luxe Cabañas. There's no evidence that Royal Realty lost the opportunity to generate these fees because they could have provided management and operating services to other third parties. They are indeed still operating the Charlie Hotel, and the know-how that was mentioned by the claimants today is the claimants still have it, so they could put it to use and instead of claiming in this arbitration. The claims are also exaggerated because they are highly based on the exaggerated assumptions that we mentioned before. Then, next, please. There's also a claim of 15.6 million for future hypothetical projects. This is absolutely and entirely speculative because there's no evidence at all of any such future hypothetical project, that it would exist, that it would succeed, and even if then the valuation is exaggerated because, again, it's based on the exaggerated assumptions that were considered for the claimant's valuation on real estate business. Now, just to conclude, the DCF valuation, and this is a very helpful table because it compares Dr. Hearn's cost approach and his corrected DCF approach that you will see is largely consistent as expected because, as we said, this is a competitive margin, and it's ridiculously lower than BRG's exaggerated DCF valuation. Just to finish, the claimants are also claiming moral damages. It has been demonstrated at the opening, and it's also explained in the PHB, that moral damages are only applicable or may only be granted on exceptional circumstances such as physical threat, illegal detention, kidnapping, forced disappearance. None of this has happened here. So not even close to it. And we saw also, if I may refer to a table that we had in our opening, comparing the amounts granted in other cases where human rights had been breached, including, as I said, forced disappearance and assassination, and the amounts granted were far, far lower than the amount claimed by the claimants or by Mr. Seda in this case. I don't know if we have any time left. No. Then
1 minute.
Yes, do you want to wrap up? Or?
I'll just thank you, Yael. I'll just finish by the reverse order of what Ms. Rybko said, that as you will have seen, that there is no case on damages. It's all inflated. And again, it's Mr. Seda playing the casino. As Ms. Herrera has explained, there is simply no breach of the treaty. The only legitimate expectation of Mr. Seda and his acolytes should have been that by allegedly investing in Colombia, they are investing in one of the worst regions and the most dangerous regions, and then the due diligence was on their burden, and they didn't do that. And I'm not going to re-argue what Ms. Herrera explained. But really what you should decide is that this case is a case where you do not have jurisdiction, and as you know, you do not have the power to decide. The invocation by Colombia of its essential security interest in relation to an extremely grave and serious set of circumstances. And we thank you, the Tribunal, for its patience, and if there's any questions to be addressed tomorrow, we're happy to take those. If not, we will just proceed with rebuttal.
No, as agreed, we will ask our questions tomorrow. So this is the end of today's pleadings. We will then start tomorrow with the rebuttal, and then hear you with the rejoinder rebuttal. And we wish you a good evening. Marcus and I will have a drink because today is the German national holiday. We're celebrating our reunification, and so you can see how serious we take your case that we sit on a national holiday. So, thank you. Good evening.
Thank you. Thank you, David. and the interpreters.